Parrish-Sams, we welcome you to the commission this afternoon, and you may begin your opening statement.
Thank you. My full name is Rebecca Saffin Parrish-Sams, but my friends all call me Saffin. I was raised in small-town Iowa in a middle-class family and graduated from Mount Vernon High School in 1989. I worked throughout most of my high school, college, and law school years to help pay for my education. I graduated from the University of Iowa in 1993 with a BBA in Finance, an International Business Certificate, and a minor in Japanese. While attending the University of Iowa College of Law, I was the senior note editor for the Journal of Transnational Law and Contemporary Problems, and involved in many student activities and faculty committees. During my third year of law school, I gave birth to my biological son the first day of winter break, the day after finals were over. Despite the challenges of being a single mom to a newborn baby and the demands of law school and the Journal, I graduated on time in the spring of 1998. That was with the support and help of family and friends, and I did that with distinction, managing to keep my grades at a high level. I valued my Iowa upbringing and recognized the superior quality of life that Iowa had to offer, so I chose to stay here to raise my son. I worked for a year in a judicial clerkship here in Polk County, where I assisted several judges with both civil and criminal matters and a judicial review of agency decisions. I then went to work for the law school of Huber, Book, Cortez, Happy, and Brown. I worked there for 3 years, primarily representing businesses and insurance companies in matters such as contract disputes, construction litigation, ERISA subrogation, and defending claims such as sexual harassment, workers' compensation, personal injury, and professional negligence. In 2001, I met my husband, Eric Sams, at St. Mark Lutheran Church. Eric's wife had died very suddenly when his boys were only 6 years, 3 years, and 7 weeks old. Eric and I were married in April of 2002, and I later adopted his sons, making me the proud mother of 4 rambunctious young boys. My family continues to be actively involved in St. Mark Lutheran Church today. In 2002, I was asked by one of the partners at the Huber firm to start a new law firm with him. I was only 4 years out of law school and the newlywed mother of 4 when I became a partner in the law firm of Hickson, Brown, and Parrish-Sams. While there, I began to develop a plaintiff's practice representing injured Iowans in medical malpractice, personal injury, and workers' compensation cases. At that time, I also continued to represent various businesses on various matters in state and federal court. Since 2006, I've been a partner with Mark Soldat in the law firm of Soldat and Parrish-Sams. Here I have continued to represent injured Iowans in workers' compensation, personal injury, and medical malpractice cases. I've provided this brief background because I believe that I have the kind of balance and experience that Iowans would like to see in a justice. I am a soccer mom, volunteer, church member, and small business owner. I've worked hard all my life and have balanced my family and my career as many Iowa mothers are called upon to do. I have represented injured Iowans and businesses as plaintiffs, and I have also defended businesses and their insurance companies. I've practiced in state court, federal court, and administrative agencies on a wide variety of claims. I have a varied life and legal experience. This makes me well-balanced and enables me to empathize with and see all sides of a dispute. I've been practicing law now for 12 and a half years. I am 39 and I will turn 40 in May. I would not be the youngest justice ever nominated or appointed. Justice Newman was 38 when Governor Branstad appointed her to the Iowa Supreme Court in 1986. My age, like my gender, would simply provide added balance to the court. The Supreme Court is also responsible for administering Iowa's court system and is likely to face added budget challenges this year. I have a BBA in finance and experience owning and running a business, both of which I think would be extremely helpful in dealing with these administrative issues. I applied for this position because serving on the Iowa Supreme Court has been an aspiration of mine since law school. More importantly, I applied because I believe in our judiciary, I believe in public service, and I recognize that there is a great deal of work to be done to restore the public's confidence in our court system. I feel that I am the kind of person who can mend the necessary bridges. I would do this through hard work, community outreach, common sense, patience, and empathy. I have a long track record of public speaking and community involvement. I feel comfortable with the dialogue and outreach that will be necessary in order to restore the public trust, while being ever mindful that the Judicial Code of Conduct mandates impartiality. In addition to my respect for our judicial system, I also believe strongly in Iowa's merit selection system. Many of you took time out from your busy schedules to interview me. Each of you asked very insightful questions aimed at discerning legal ability, integrity, and impartiality, regardless of whether or not I am nominated for the Iowa Supreme Court. I would like to reassure all Iowans that they should feel confident in the commitment of this nominating commission to choosing the best possible applicants to name as potential Iowa Supreme Court justices. And with that, I'd be glad to take any questions that you may have of me.
Let's start on the right side this time. Any questions? Mr. Fitzgibbons.
Thank you, Your Honor. I'm sorry. Good afternoon, Ms. Parrish-Sams.
Good afternoon.
How are you?
Just fine.
Good. I very much appreciate being part of this process. I know it's a lot of work, and we've thanked everyone involved, and we thank you as well. As you know, as the Iowa Supreme Court is currently constituted, there are no women. If you looked around the United States at the appellate court level, or perhaps there's certainly at the appellate court level, that's unusual. Tell me what our commission here today and the rest of this week should do as far as making that a consideration. Should we not? If we do, why? If we don't, why not?
Well, I think that there are a lot of considerations that go into picking the proper applicants to nominate for the Supreme Court. Gender is only one of them. Obviously, you want someone who is qualified and who is capable of taking on the responsibility of the legal interpretations and the writing that is involved in this. There's also the responsibilities of administrating Iowa's court system. But on the other hand, there is also the sense of fairness that comes about from having a balanced Supreme Court. I don't know that there's any magic formula that the commission should be looking at. I don't know that gender is the only issue of balance that should be considered. I don't think it is. But I do believe that balance is important. It is especially important right now as we try to regain the public's trust in our judiciary.
Any other questions on the right side? How about to my left? Anybody have a question? Mr. Holmes.
Good afternoon.
Good afternoon.
Thanks for being here. You've had a really varied legal career for such a young attorney, and I'm wondering if there has been a case or a type of or cases from which you feel you've gotten the greatest professional satisfaction.
I like, it wouldn't be necessarily a particular type of case, but it would be, the thing that with which I have the most satisfaction is seeing the satisfaction in my client's eyes when we are done. And that would go both to representing individuals who at the end are so thankful that you've taken the time to care, taken the time to fight for them. But I can also say the same thing about small business owners that I've represented. There's one particular case that I'm thinking of where I can't tell you how thankful the small business owners were when I was done with that case. They didn't have insurance for the particular kind of claim that had been brought against them, and it was a long-fought battle. It is seeing that satisfaction in the eyes of the person that you're representing at the end of the day. That is what's most important.
Any other questions on this for Mr. Cook?
Mr. Fitzgibbons asked you about gender, but I wanted to ask you about some of the other comments you made in your papers here about when you were asked how would your appointment enhance the court, and among the things you said were, one, I'm a soccer mom, and two, I'm from the younger generation. And explain to us your view as to why that would enhance the court.
Well, I can tell you that being the mother of 4 boys has taught me a lot of patience. It's all about balance. It's been about balance as I've gone through my career. I've had these 4 young children who now aren't so young anymore. They're 3 of them are teenagers. It's about real life experience. I mean, what you do outside of work defines you as much as what you do while you're in the office. So I think that balance is important. I also think that, there are a large number of children whose rights are affected by decisions within our judicial system. Sensitivity to those issues is important. So when I say I'm a soccer mom, that doesn't just mean I take my kids to soccer. It's just that I'm actively involved in my children's lives, and I understand that women who come before the court, children who come before the court, and of course fathers who come before the court, there is a whole dynamic there that I am sensitive to, and that's part of empathy, and it's part of patience. As far as my age is concerned, each generation has a different way of looking at things. Maybe they're not so different, but part of our judicial system is that at the end of the day, people need to feel like they are heard. People need to feel like their particular point of view has been given consideration. And when you have more balance to the court, whether that be through age, through gender, through ethnicity, through religious backgrounds, through whatever it may be, feeling that as though people are listening, people are hearing what you have to say before the case is decided, whether that is decided in your favor or against you, that is part of our justice system. And in the long run, I think people feel more satisfied with that if they feel that there are people there who can listen, understand, and empathize, even if it's decided against them.
Any questions this way? Ms. Walker?
Thank you, Ms. Sams. With regard to the difference between practicing law and being on the bench, do you think you would have any difficulty shifting from an adversarial position to a more neutral position where you're on the bench as compared with your practice?
I don't think so. And that's for a couple of reasons. One is that I have practiced on both sides. And I've made that transition. I spent a period of time where I was representing both businesses and individuals. And so I've had that varied experience that I think enables me to step back and look at the middle ground. I also think that if you look at letters of support that I have received from various attorneys across the state of Iowa, you'll find that a lot of those letters come from people who've been on the opposite sides of cases from me. And I think that you will find that they felt that I was able to see things from all sides, that they were able to work with me on a professional basis and found me to be a reasonable person to deal with. And the reason is that there's always a bigger picture to look at. So even when I've advocated for my clients, I've tried to be aware of that bigger picture. Because I've always advised my clients of that bigger picture. While I may take a particular stance on their behalf in court, it's my job always as an attorney to advise them about the other side. You never do a client service if you're only looking at it from one point of view. Part of keeping your clients informed has always been to advise them of the other side. And so while it would be a change to try to look only at it from the impartial, neutral standpoint, I don't think it would be too big of a change for me because I've always tried to find that middle ground.
Any questions this way? I have a question. How many jury trials have you tried in your career? The verdict?
2 verdict. One to verdict in front of a jury,
And how long ago was that?
2008.
And what would you characterize your practice now as primarily?
At the present time, my practice is primarily work comp. I have recently stopped doing as much of the medical malpractice and personal injury. And the reason was simply that I've strived for balance, and that required a lot of out-of-state travel, dealing with experts and things of that nature. And so I made a commitment to my husband that I was going to be home instead of gone quite so much.
You know, I don't mean this in a derogatory sense, but how many different district or counties have you appeared in the courts in the state over your career?
Counting, well, I mean, probably 8. Probably, I haven't counted, but I would say probably 8.
And would that be mostly in the central Iowa area?
No. And with respect to the workers' compensation practice, I guess I wasn't including that, but I have clients from all over the state of Iowa for workers' compensation. It's just that most of those end up getting heard here in Des Moines.
You've talked about judicial administration, and I don't know if you're aware of it, but Chapter 602 of the Code sets up a judicial council, which the legislature has set up, which consists of chief justices, court administrators, the chief of the Court of Appeals, and the chief of the Supreme Court, whose function is to receive input from all the different districts, talk to their local people and all levels, and come up with solutions to problems that may be statewide or even maybe even to a district. How would you change or enhance that procedure in the administration part of the function on this job?
Well, a dollar can only be spent in so many places. And so there are realistic constraints on what can be done with the budget that is set. But just like with our judicial system, I think there's more satisfaction in terms of the decisions of what to do with that dollar if people feel that they've been heard and that their points of view have been considered. So I think it's important to reach out to the various district courts and solicit input from them. Some of that can be done through a committee. I think that also some of that can be done through simple informal phone calls just to check in with people, hear what their concerns are. And I realize that the Supreme Court doesn't necessarily have the time to speak to everyone, but it's like with everything else in our society. If you feel that you've had a chance to be heard, you're likely to feel more satisfied with the ultimate result that comes down, whether it is the one that you advocated for or not.
Is it your impression that the Supreme Court's not doing that now?
No, I just think that with the recent election, retention election, I think that there is probably, things have become more vocal, and perhaps there are more people who feel like they need to be heard now.
What's your sense of what that election was about? Was it about not reaching out to people? Was it about one decision? I mean, what is your sense about what that election was about?
Well, I mean, there's a lot of labels that are being thrown around. Now, I don't know that those labels necessarily reflect everyone's opinion with respect to why they may have voted for or against a particular justice. I think that there are probably a number of factors that went into that. Obviously, the Varnum decision is one. I think that there are also those who routinely vote against retention of judges and justices in any given year. I think that there is some dissatisfaction at the local courts with the fact that we've had budget cuts that have had to be dealt with. We have clerk of court's offices that have to close early. We have cases that are being delayed, whether they be civil, criminal, or child custody issues, divorces, foreclosures. There are all those kinds of things where people are having to wait. And so I think that that also played into what happened with our retention elections, because people don't understand why they can't have their day in court, have their justice sooner, and why they're having to wait. And so some of that, I think, is a result of the economic conditions as well.
Okay, thank you. Any further questions here? We have time for a quick one. Mr. Michelson?
What do you think about, you're talking retention, what do you think, is there a better way to publicize what retention is? Or does it need change? Does it need updated?
I think it's incumbent upon the bar, the judiciary, everyone at this point to reach out to regular Iowans. I'm not sure they truly understand our judicial system. We have relied on civics education in the schools to explain that to people at this point. And I think that we have now learned that perhaps more needs to be done. There is a public dialogue that's going on. And you know, Justice Cady did a nice job in his State of the Judiciary speech in starting to enter into that dialogue. I know not everyone was pleased with what he had to say, but I was pleased because it is a first step in terms of reaching out to the public to try to enter into that dialogue. And I simply think that there is more dialogue that needs to go on, and there's going to be a call to the newly appointed Supreme Court justices as well as the existing Supreme Court justices to try to reach out to people and explain our system a little bit better in ways that they can understand and truly value what we have.
Any further questions? Well, we thank you very much for spending the time with us today, and we wish you good luck.